Hello all, I'm Guna Mathivanan. Welcome back to Simply Current Affairs. So in today's Current Affairs Hitlist, we are going to discuss two important topics. But before going into the topic, friends, if you are looking for some support for revising economy, environment, geography, we have our quick revision program where in 15 hours, each subject separately will be discussed. So if you spend 3 days, you can finish revising all these 3 subjects. To know more about our QRP program, you can visit our website www.simplycurrentaffairs.com. In the home page, you have courses section where you have more information about our programs. IPR watch list. IPR watch list, Intellectual Property Right watch list. See, United States, America, what they do is they will maintain a list. That list is a list of countries. Those are countries in the eyes of America. They are not providing sufficient protection for the intellectual property. So, IPR watch list, that is a list maintained by USA. That is a list of countries. List of countries. These countries, on the eyes of USA, these countries are not providing sufficient protection for the intellectual properties. So in this list, India's name has also been included. India is among the 8 countries including China and Mexico as per the priority watch list. Okay, so now more than this, we should know what is this intellectual property. What is this intellectual property? Intellectual property that refers to creations of mind. It can be invention, literary work, artistic work, symbols, names, designs, images, anything. And these intellectual property has to be protected. In India, we have laws protecting this intellectual property using various tools like patent, trademark, copyright, etc. Right? Ministry of Commerce and Industries, under which we have Controller General of Patents, Designs and Trademarks. They will look after the grant of patent, design, trademark as well as geographical indication. See, what is this patent? So, patent is a right given to an invention. Now, Guna is inventing. Now, Guna is inventing something novel, something new. Guna is inventing. Okay. So, if it is novel, and it should be an inventive step. It should not be very obvious. It should be novel, it should be inventive, and it should have some industrial application. So, if it satisfies these 3 conditions, then my creative work can be protected, my invention can be protected through a patent. Now, for example, imagine Guna is developing a pen, inventing a pen, magic pen. So, what is magic about this pen, sir? Now, imagine whatever I write in this pen, automatically that is getting stored inside this pen. And whenever I want, I can make the pen to write for myself. Just randomly, I am saying. Imagine, so this is something new, right? This has a lot of application also. Now, I am developing something new like this, and I can protect my invention through patent. So, when I protect through patent, the patent will be given for a specific time period. Let us say 20 years. In Indian case, we are providing for 20 years. For 20 years, it is only Guna who can produce this pen. Others cannot produce. If others has to produce, they have to get permission from Guna. They have to pay royalty to Guna. That means they have to simply pay a share of revenue to Guna. So it is completely under the control of Guna. Guna will be having the exclusive right to produce this magic pen for 20 years. Right? The patent is granted for 20 years. So it is governed by Patents Act 1970. Does Indian patent protect worldwide? No, there is nothing called as global patent. Now, Guna has developed this pen and Guna has applied patent in India. If Guna wants the same protection in other countries, Guna has to go and apply. In America, Guna will go and apply. In Australia, Guna will go and apply, like that. Okay. So, this is regarding patent. The next one is regarding the copyright. So, what is this copyright? Copyright simply refers to right to copy. Now, I am coming up with a music album. So, I am copyrighted with my album. So, when I get the copyright, only Guna will be having the power to make copies and sell it in the market. I am writing a book. So, I get the copyright. That means that book only Guna can make copies and sell it in the market. Trademark. Trademark is given for some design, some expression, some symbol. For example, the moment you see these 4 rings, you will say this is a trademark of Audi. Now other companies, Maruti or Hyundai, they cannot use this symbol. So this symbol will identify the product. So that symbol, that design can also be protected under something called as trademark. Industrial design, see, these are something to do with the shapes, configuration, surface pattern, colors applied. For example, look at the Coca-Cola bottles. The bottle design, that comes under industrial design. The Coca-Cola color, okay, the Coca-Cola, they use a specific kind of color, red color, okay, not red exactly, they use a specific color. That color they can apply for industrial design. They can prevent others using from the particular combination, okay. So this is regarding industrial design. So we discussed copyright, trademark, industrial design, all these patent, all these are intellectual properties. All these are intellectual properties. In protecting these intellectual properties only, according to the America, India is not doing well. Okay, that is why they have kept us on their watch list. The next topic is regarding compulsory licensing. It is related to the intellectual property only. Compulsory licensing. See, now Guna is a pharma company. Guna is running a pharma company, and Guna has found a vaccine. Guna has found a drug or vaccine, whatever. Guna has found a drug, and this drug can cure COVID. This drug Guna Pharma has developed. This drug Guna Pharma has developed this drug. This drug can cure COVID. And Guna Pharma has applied for patent, and for 20 years only Guna Pharma can produce this drug. Others, if they have to produce, they have to get permission from Guna Pharma, give the royalty, etc. Now, during some emergency situation, Indian government can issue compulsory licensing and ask some other, not just private, can ask other pharma companies to produce the same drug. Understand, Guna Pharma has spent a lot of time, energy, money, research, took risk in developing this drug and got patent for 20 years. That means only Guna Pharma can produce this drug. But however, on the grounds of some emergency situation, Indian government can issue something called as compulsory licensing that can allow other pharma companies to produce the same drug. And this is going to violate the patent right? Of course it violates, but Government of India has the power. In an emergency, there's a medical emergency. People are losing their life. So in order to protect that time, we cannot give priority to the business. We should not give priority to the rights. People life is more important. So in that situation, Government of India issues something called as compulsory licensing and will ask other pharma companies to produce the same drug. This is going to violate the right of Guna Pharma, but still Government of India can do. There's something called as voluntary licensing. Voluntary licensing is in many pharma companies. In the event of emergency, even if they hold patent, they will allow other pharma companies to produce on the ground of goodwill. They will do it. That is called as voluntary licensing. If the company Guna Pharma is very bad, they are not providing voluntary licensing, then Government of India will simply issue compulsory licensing and ask other pharma companies to produce. Whether such incident has happened in India? Yes, in 2012 it happened in India. See, Bayer, Western, I think a European pharma company, they produced a drug called as Sorafenib. Sorafenib is the drug name, Nexavar is the brand name. This is a cancer drug, a life-saving cancer drug. This drug, 1 month drug, was sold for almost 1.2, 1.3 lakh rupees. So in 2012, Government of India, they issued compulsory licensing of this Nexavar, asked Natco, a pharma company in India, to produce the same Sorafenib, to produce the same sorafenib drug, and this drug was sold for some around 8,500 rupees. What was sold for almost 1.2 lakh rupees was sold for 8500. Right? So this is called, only once India has used this compulsory licensing. Now you might ask a question, sir, whether WTO allows these kind of relaxations. Yes, we have heard about TRIPS. TRIPS is a WTO agreement, trade related aspects of intellectual property rights. This is an agreement which covers different form of intellectual properties, including copyright, patent, trademark, GI, geographical indication, industrial design, and trade secrets. Okay, of course, TRIPS is an agreement to protect the intellectual properties of different countries, but however, the TRIPS agreement has the provision, the WTO has the provision for compulsory licensing. Okay, the TRIPS agreement was amended in the year 2001 in the Doha Ministerial Conference of WTO. The TRIPS agreement was slightly amended. So what is that amended feature? Just for your awareness, what is the amended feature? Now imagine a situation. Now Sri Lankan government is issuing compulsory licensing. It is asking a Sri Lankan pharma companies to produce a particular drug. But assume that the Sri Lankan pharma company is not able to produce, they are not having the capacity to produce. In that situation, the Sri Lankan government can ask an Indian pharma, so Guna Pharma is there, can ask Indian pharma company to produce the drug. So a country, they are issuing compulsory licensing, but that country is not having the capacity to produce, they can get the help of other countries, that is the amended TRIPS. This is just for your knowledge. What you have to know is, compulsory licensing is allowed under the WTO's TRIPS agreement. That is what you have to know. Right, I hope you got clarity on the topics what we have discussed today. So any feedback you can give it in the comment section. So I will see you in the next Hitlist video. Till then, bye. Take care from Guna Mathivanan.